We had a major oral argument in the state of Illinois over whether or not the Second Amendment is violated by virtue of the state of Illinois requiring Americans in that state to get a firearms owner identification card to possess a firearm. Big fight, big case, guns save life versus Raoul out there in the appellate courts in the state of Illinois. We're going to break it all down when we get them right back. Hey folks, I'm Mark Smith, host of the Four Box and Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the recent law review article in the Georgetown Journal of Law and Public Policy, Dangerous but Not Unusual, Mistakes Commonly Made by Courts in Post-Bruin Litigations. This is the article you want to read if you want to understand how to apply the Second Amendment to modern lawsuits and challenges involving gun control laws. You definitely want to know this if you want to know the most recent scholarship, arguments, principles, and the like in fighting for our rights in court. Check it out in the Georgetown Journal of Law and Public Policy. A link to the article is down in the description of this video. All right, folks, we had a major oral argument in the case of Guns Save Life versus Raoul out there in the state of Illinois in the Illinois 4th District Appellate Court. 3-judge panel. Big fight. State of Illinois on one side, the attorneys for Guns Save Life on the other. And this turned on the question of whether or not the plaintiff's facial challenge to Illinois' firearms owner identification card law is constitutional. Now, under the Firearms Owner Identification Act, it requires all Illinois residents to acquire a license and pay a fee in order to be allowed to possess, listen carefully, to possess a firearm. This is not talking about concealed carry licenses to get a license to carry a gun in public for self-defense. We're talking about a license to possess a firearm. As you know from the text of the Second Amendment, which reads, "The right of the people to keep and to bear arms shall not be infringed." To bear means to carry guns in public for self-defense. To keep means to possess arms. This is not a licensing case involving the right to carry guns in public pursuant to, let's say, a shall issue permitting regime. This is a different question. This is, can the government require a license for you to be able to keep arms, which means to merely possess them? So this is a lawsuit that was brought challenging this law, claiming that it violated the Second Amendment. Now, a big part of the argument, and I'll try to put a link to it down below so you can listen for yourself, see if I'm getting something wrong. A big part of this argument was the effect of footnote number 9 in the U.S. Supreme Court decision in 2022 of NYSERPA versus Bruin. If you remember, footnote number 9 indicated that shall issue permitting regimes for concealed carry weapons licenses are not unconstitutional. But here's the key. Footnote number 9 was drawing a distinction to the New York law, which was being knocked out by the Bruin decision. Because as you may recall, the New York law that was defeated and declared unconstitutional by the U.S. Supreme Court in Bruin was what I call a mother may I law. It basically said that in the state of New York, if somebody wanted a concealed carry gun in public for any lawful purposes, including self-defense, they had to go begging from two licensing authorities in the state to get that license. And the state did not view the right to carry guns in public as a right. They viewed it as a privilege. And they could bless you and grant you the right to carry a gun, but they had no obligation to do so. Bruin, decided by the Supreme Court, said that is a no-go zone, that under the text of the Second Amendment, the right to keep and the right to bear arms shall not be infringed means that you have a right to carry guns in public for self-defense. Footnote number 9 talked about shall issue permitting regimes, indicating implicitly that they might be constitutional under the Second Amendment, but not actually deciding the question. Because at the end of the day, the decision as to whether or not shall issue permanent regimes are constitutional will ultimately have to be decided by the Supreme Court applying the Heller-Bruin methodology of text first, burden shifting to the government to show or not be able to show a longstanding historical tradition of firearms regulation analogous to, in the case of a shall issue permanent regime, analogous to a shall issue permanent regime for concealed carrying guns. Now here, this is a much different case, right? Because here in Guns Save Life versus Raoul, we're not dealing with the right to carry guns in public for self-defense, which was the subject of Bruin. We're actually talking about licensing rules and laws associated with merely possessing firearms, including possessing firearms in your home. Now, there's two reasons why that language in footnote number 9 of Bruin may not apply here. The first, of course, is just straight up, it's dicta and not the holding, as we've talked about before. When a Supreme Court issues a ruling that does two things. One is it indicates which side, which party wins the argument before the Supreme Court, who wins and who loses. Very important, of course. But equally important, if not more so, is why they won or lost, the rationale of the court. Now here, because the Supreme Court in Bruin did not have to decide whether or not shall issue permanent regimes were constitutional, because the issue was New York's may issue permanent regime constitutional, and the answer was no, they never had to take it to the next level and decide shall issue permanent regimes. So at one level, footnote number 9 doesn't help the state of Illinois in this case because it was mere dicta. It didn't decide anything on the question of licensing regimes or licensing or permitting at all. Beyond that, even if you wanted to assume for the sake of argument that Bruin's dicta was somehow binding on the lower courts, including the Illinois 4th District Appellate Court there in the state of Illinois, footnote number 9 was about carry licensing of guns. It was not about possession licensing. And keep in mind that throughout history and even today, possession licensing is an extreme outlier. What do I mean by that? Beyond the fact there were no licenses of the sort that I'm aware of at the time of our founding when the Second Amendment was adopted in 1791. Even beyond that, if you look at modern American life in the 21st century, there's relatively few states, Illinois being one of them, that require a license to merely possess a firearm. So not only are these laws extreme outlier laws at the time of the founding and throughout our history, they're even extreme outlier laws today. So this is quite significant, I think. Beyond this, going back and forth during this argument, there is much discussion of the fact that there's already countless laws on the books that prohibit people that are prohibited from having firearms. In other words, you have all of federal law, 18 U.S.C. 922G, that lays out a whole list of prohibited people who cannot possess firearms. And why would any of these people who are prohibited that want to go out and get a firearm care one iota that they might violate yet another Illinois law if they don't get one of these firearm owner identification cards? So all you're really doing is messing with firearm owners in the state of Illinois. I should also note that the lawyer for Illinois was trying to make the argument that the text of the Second Amendment is not even implicated here. But I think that's a stretch, and I think that's a difficult argument to make, because the right of the people to keep and bear arms shall not be infringed. Their argument is that paying a modest fee and requiring someone to fill out an application to get this firearms owner identification law is not an infringement. Again, let's think about the text for a moment. The right of the people to keep and bear arms shall not be infringed. What does infringed mean? Infringe derives from to infringe. If you look at the same dictionaries that the U.S. Supreme Court used from the late 18th century, early 19th century, the same dictionaries that the Supreme Court used in Heller to define the other words found in the text of the Second Amendment, the Supreme Court defined, to keep, which means to possess, to bear, which means to carry, well-regulated, which means basically to function, and so on and so on. These words were defined by the U.S. Supreme Court in Heller by using certain dictionaries from Samuel Johnson, Noah Webster, and others. And if you look at those same dictionaries that the Supreme Court has already used to define the terms of the Second Amendment, and you look at the word to infringe or infringement, it means to hinder, And what does it mean to hinder? Well, to hinder basically means just to get in the way. So here, if you require someone to fill out a license or an application for a license, you require them to pay money. That is at a minimum some sort of a hindrance, which means that textually, this firearms owner identification law by Illinois, at a minimum, textually at least, hinders the right of the people to keep and bear arms. Because you're getting in their way, you're hindering them in some way. Even if it's a de minimis manner or de minimis way, it's still getting in the way. You're hindering it. Because of that, the burden shifts to the government, as you know, to show a longstanding historical tradition of firearms regulation, analogous to, in this case, requiring individuals to get firearms owner identification laws to be able to possess firearms. Well, that's not there in the 18th century or even in the 19th. Again, even today, these are extreme outlier laws. So I think there's a reasonably good chance that we can win this case at the appellate division. Now remember, even if the Gun Save Life Second Amendment argument prevails in the Illinois 4th District Appellate Court here, it still has to go to the Illinois Supreme Court, assuming Illinois appeals, which I assume they would. And the Illinois Supreme Court would have to make a decision in this case, one way or another. And then in theory, someone could seek cert, the losing party in the Illinois Supreme Court could seek cert to the United States Supreme Court to hear this case. So but again, you out there in Illinois, tell me, but it's my understanding that the Illinois Supreme Court right now is not particularly good for any conservative issue or any Second Amendment issue by virtue of its composition. Maybe that'll change over the next year or two, but right now, I'm guessing the Illinois Supreme Court doesn't look that good for these kinds of arguments in support of the Second Amendment, but nevertheless, anything's possible. But in the meantime, we're not there yet. We're in the appellate court in Illinois, in this case, a Gun Save Life versus Raoul. And, let's see if this firearms owner identification law can be knocked out on Second Amendment grounds. That would be very good news for Americans in the state of Illinois who have every right to benefit from and enjoy the liberty associated with the right to keep and bear arms like every other American all across this great country. All right, so there you have it. Hope you enjoyed today's show. Make sure you subscribe to the channel, show it to your friends, share it with your friends. Don't forget to follow me on X at @4boxesdiner. Don't forget, of course, to subscribe over on Rumble. For those of you, there's a lot of people who prefer Rumble over YouTube for various reasons. So I'm now posting these videos on Rumble as well. And again, with that said, I look forward to talking to you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.